There is a new rule out of the U.S. State Department that could actually make it harder for a pregnant woman to get a visa. This is effective January 24th, 2020, and it amends the regulations that govern the B non-immigrant visas that are available to visitors coming to the United States for business or pleasure. Now, the definition of business or pleasure has been a long-standing list of things like tourism, visiting with friends or relatives, medical treatment, rest. It's quite a list, but medical treatment is the one that's at issue. There was concern by people in the Trump administration that people were coming to the United States as pregnant women with the sole purpose of delivering their child in the United States so that that child could instantly become a U.S. citizen. Now, this new rule will let the consular officers determine if that was the primary intent of someone coming from this point forward. The rule specifically states that if your purpose of pleasure of coming to the United States for that B non-immigrant visa is to obtain citizenship for a child, you will be excluded from entry. The rule adds a provision to deny entry from that medical treatment bullet point unless you can prove that there is a legitimate reason why you wish to travel to the United States for medical treatment, that a medical practitioner or facility has agreed to provide your treatment, and that you can also specify the projected duration and cost of your treatment in addition to any incidental expenses as long as you're in the United States. So you as a person coming to the United States seeking a B non-immigrant visa will have to have these facts ready to go to present to the consular officer, who then will make a judgment call if that medical treatment is legitimate. The applicant also has to show that they have the means and intent to pay for the medical treatment. So this is very similar to some of the other immigration proclamation rules we've seen out of the Trump administration, where you have to show you have the means, you have the money available to pay for medical treatment once you come on that visa. Now, you also have to show that you have things like transportation, living expenses, and can be otherwise self-sufficient while you are here. And this has to be to the satisfaction of the consular officer. So this is a very subjective test once again. Now, a lot of the purpose behind this is coming out of the Trump administration, which has been very vocal on cutting down on what they call birth tourism, people coming to the United States to deliver what will then be a U.S. citizen child, even though they readily admit that they don't have the data on how many people actually come to the United States for that specific purpose. So there are millions of visas that are approved in any given year. Maybe hundreds or thousands are for this purpose. We don't know. We don't have the data from the State Department. Critics of this rule are mostly concerned with the subjectivity part of the language in this rule that puts a lot on the consular officer and their health policy experts that say, and immigration attorneys that say, health consular officers don't have medical training, and they're being asked to do quite a hefty lift to determine the medical treatment and medical emergency that may be present from the individual that is seeking entry to the United States. They're the people that will be adjudicating a person's pregnancy, and they may not have all the information they need to determine if it is medically necessary. There is no appeal process. If the officer says, nah, I don't think that you should come for medical treatment, there is no appeal to a higher power to see if that decision was appropriate. Now, a visa applicant could simply try again. They could reapply, but then you are put back in the position of being at the liberty and whim of the consular officer once again. So this rule is in effect. We link to it in the description below so you can read the language of the rule and some of the motivation behind it. We will keep you posted as more language comes out of the State Department and Department of Homeland Security on other immigrant visa considerations that are happening at the same time. Make sure you subscribe so you can stay up to date.